kind introduction, and I'm very happy to be here with you today. And I very much appreciate the fact that you've taken so much time out of your busy schedule to listen to the webinar. As Cal had mentioned, it is a pretty ambitious agenda, and I am trying to move the slides along here. There we go. To upload the details of the agenda for today. And as Cal had mentioned, the, genesis for today's webinar came out of the numerous questions that were posed to Deborah Grant when she did her webinar on consent under PHIPA in the Ontario context. And so Cal had asked me if I would deal with consent issues specifically consent issues related to the use of health information for research. And in essence, that could be a very short webinar, because the fact is that as long as you meet certain requirements, which vary depending on the province, you may use and disclose health information without consent for research purposes. So then we got to thinking that it would be expanded further and deal with research issues generally in the provinces of Ontario, Alberta, and BC. And having said that, I guess the scope went from being potentially very short to, being very long. So what I propose to do today, is to start with Ontario. And I understand that most of the webinar attendees are from Ontario. So I'll do a fairly deep dive into the requirements under PHIPA, which is the Health Information Privacy Legislation here in this province. And then I'll move along to Alberta and BC and summarize with a chart, which is sort of like a little bit of a checklist indicating some similarities and differences between and among the three provinces. I will say that I do certainly want to leave time for questions, as Cal had mentioned. So it may very well be that I don't get to all of the material on Alberta and BC. But as Cal had mentioned, the slide deck in its entirety will be available on the eHealth website probably by the end of the week. And it does contain the information from those provinces, even if I don't have a chance to specifically address them today. This next slide I just put in here to, give you an overview of the complexity of not only the Canadian privacy law environment, but specifically that applies to health information privacy in the country. And first of all, a disclaimer: this is not my slide. It's a free resource produced from a company called Nimity, which has a lot of privacy advisory services. And I'm not promoting that company, nor am I vouching for the accuracy of the slide. But I just thought it might be helpful to illustrate why, based on my understanding, researchers across the country have said that it's very, very difficult to sort of get access to privacy information, health information legislation rather, from different provinces for pan-Canadian research projects. And so if you look at the province of Ontario, what I will be focusing on today is PHIPA, legislation applying to health information here, Alberta, the Health Information Act, and as we move out to the West Coast, you'll see actually in British Columbia, there are two pieces of legislation, two laws, that are relevant to research and health information out there. And they are what we call FOIPA, Freedom of Information, applying to public sector organizations, so that includes hospitals, for example, and PIPA that applies to the private sector in BC. That would include doctors' offices, labs, pharmacies, that kind of thing. So let's just move on to Ontario. So if you want to take a trip to any of the provinces, these are tourist maps that just so we know the geographic boundaries of what we're going to consider. In the context of PHIPAA, that's the Personal Health Information Privacy Laws in Ontario, I thought it might be helpful to lay a little groundwork. This will be review for those of you who listened in to Deborah's webinar, but I think it's important to set the context for how the research rules work. So PHIPAA is what we call consent-based legislation. And by that I mean the rules in PHIPAA say that custodians being, for example, all the organizations that manage PHI, personal health information in the province. So we'll take hospitals, doctors' offices. It includes both public and private sector. So, for example, the Ministry of Health is a custodian. And the rules say that these HICs, these health information custodians, may only collect, use, or disclose PHI if one of two conditions in the Act are satisfied. So these two conditions are the individual's consent is obtained, or the activity dealing with the information is permitted or required under the Act. So for research purposes, as an example, unless you have consent or those purposes are specifically stated in PHIPAA to be able to be undertaken without consent, you can't do them. So this consent-based scheme in PHIPAA is one of the characteristics that have led to its designation as being substantially similar to PIPEDA. And I only mention this because some of you may be familiar with some of the work that CIHR has done with respect to research requirements under PIPEDA, which is the federal law that applies to private sector organizations such as pharmaceutical companies, for example. So, to do a quick review, consent may be express, implied, or in certain cases, assumed implied consent. And the type of consent that PHIPAA requires depends upon the purpose for which the information is being collected, used, or disclosed, and or the nature of the entity that's involved in that particular activity vis-a-vis managing the information. So, for example, you need express consent for marketing. You can rely on an implied consent for most purposes under the Act, and assumed implied consent with respect to disclosures by custodians within the patient's circle of care for healthcare purposes. And there are 4 criteria that must be satisfied in order that consent is appropriate under the Act. So it must be that of the individual, or we have substitute decision makers, knowledgeable, relate to the information, and not be obtained through deception or coercion. Now, you'll recall 2 circumstances in which custodians may collect, use, or disclose PHI under PHIPAA. Consent, which we briefly touched on, and the second situation is where the activity is permitted or required by PHIPAA. And basically, these types of activities are those, they represent policy decisions by the folks, that the legislators, your members of parliament, that activities that were assessed to be of great social value, such that the use of the information was deemed to trump, if you may call it that, an individual's right to privacy, so that the information may be used without obtaining the individual's consent. So some of you, for example, may be aware of the studies that were done many, many years ago by the Mayo Clinic, and they were inspired by the fact that the state of Minnesota introduced health information privacy legislation that required individual consent prior to using the information for research purposes. So the Mayo Clinic did a number of studies in which they identified that the populations who would consent to the use of their information for research purposes differed substantially on many criteria that were relevant to the research from those populations that declined to provide consent. So the studies resulted in the concept introduction of consent bias, which, while it may be controlled by statistical manipulation of the data, does make it very difficult to generalize any research results based on information obtained with consent. So the Minnesota privacy legislation was subsequently changed. So that provides an example of one of the policy drivers that was incorporated into PHIPA here in Ontario. And as a matter of fact, in the legislation in Alberta and BC that says you may collect, use, and disclose personal health information without obtaining individual consent, but along with that right to do that comes a number of responsibilities, and these responsibilities are set out in the legislation itself. So it's important to remember, before we get into the details, that PHIPA has two overriding, or what I call overarching principles in it. And these two are very, very relevant when you're looking at information used for research purposes in particular. The first principle is that you don't collect, use, or disclose PHI if other information would serve the purpose. So in PHIPA, personal health information is defined as identifiable information. So what that means from a practical purpose is that only if the information is PHI, that is, only if it's identifiable, do the research rules apply. And so if you're thinking about engaging in research and the information, if you give it a good hard think and you really don't need it in identifiable form, then not only will you be complying with this principle, but then depending on the degree of identifiability and other protocol issues, you may well not have to go through all the research requirements of the Act. The second principle is the data limitation principle with respect to the amount of information. And I think sometimes what happens, and very often it's just because of ease of use, time or money, it may be easier for a custodian to say, well, we've got this database, it's got, it's a record level database, and for each record it has 25 attributes in it. And if you're thinking about what your research protocol is all about, you really only need 10. And as I said, from an ease of use perspective, maybe easier for the custodian to just ship you or provide you with access to the entire database, including those unnecessary 15 data elements. And what PHIPA says is, don't collect user disclose any more than you need to serve the purpose. In this case, it would be your research purpose. And if you think about it from a practical perspective, one of the drivers of this statement is, of course, the more information you have, the more risk you expose your organization to in the event of a data breach. So these are two overarching principles that actually should be considered both by you as a researcher when you're seeking to access data for research purposes, and the custodian from their perspective with respect to what data they will provide to you. So while those of you that practice in the field, I'm sure, have a sense of what research means to you, but I think it's important to have a quick look in any event at the definition of PHIPA. And it's kind of, I suppose, one might call it a motherhood definition, a systematic investigation designed to develop or establish principles, facts, or generalizable knowledge, any combination of them, and it includes development, testing, and evaluation of research. Now, one of the reasons that it's important under PHIPA to do an assessment of what you're actually doing with the PHI and whether it falls within the research definition is because there's a lot of other activities that we know involve PHI that may not be research. So, for example, there are things like program monitoring, program evaluation, and under PHIPA, many of these other activities may be undertaken as well without the individual consent. But the difference is, if you are doing research as defined in the Act, the research requirements come into play. Now, admittedly, sometimes it's very difficult to draw the line, but the consequences of how you characterize what you're actually doing with the PHI do have implications with respect to compliance requirements under the Act. So I'd like to turn now to what PHIPA says one has to do if you are seeking access to PHI to use for your research purposes. So the first scenario that I'd like to consider is that of disclosure of the information for research purposes. So let's take this example. You have a research project and it requires that you access PHI from hospitals. And in your view, you require identifiable information to test your thesis. So, what do you have to do? Well, PHIPA is pretty, what I call prescriptive, i.e. it lays out very, very detailed requirements for many aspects of the process that must be undertaken in order that you can access that information. So, and one other thing that I'd like to mention that often seems to get forgotten when people get involved in the details of research projects, and that is the disclosure by a custodian, and we'll take our hospital in this case, for research purposes is what we call discretionary. That means the hospital does not have to disclose the information for research purposes. So even if you as a researcher satisfy all the requirements under PHIPA, you've got all your T's crossed, your I's dotted, the hospital may still decide not to disclose the information. And that's to be contrasted with situations where there's an obligation, for example, for particular law enforcement purposes. So, I mean, it is a lot of work, and there's a lot of process and paperwork involved, but at the end of the day, the decision to disclose the data or not for research does rest with the custodian. So, obviously, from a practical perspective, it's definitely a good idea to have discussions up front with any custodians for whom you're going to be seeking access to the data before you march ahead and go down the road to getting all of these processes and documents in a row. So, what are your obligations as a researcher? So, basically, there are two obligations that sort of break down into a number of different things. And one of the things I'd like to highlight about how the research scheme works in PHIPA is that if you or somebody is looking at the legislation itself to sort of say, okay, what do I have to do here? Please remember that the entire research process is to be found both in the Act, Section 44, and in a suite of the regulations that go into a lot more detail. So don't forget about the regulations if for whatever reason you decide to do some research on this yourself, because they'll provide you with very important information with respect to your requirements. So, the process is, as a researcher, you have an obligation to do two things. You prepare a submission to your custodian, so that's the hospital from whom you're seeking the information. And you need to include three things in there: your written application, your written research plan, and a copy of the REB decision, the Research Ethics Board decision, that approves the research plan. And then once you've submitted those documents, those materials to the HIC, and the HIC has agreed that, yes, they will release the information for your research, then you'll have to enter into a research agreement with that custodian that includes a number of different parameters. So the research application itself, there's nothing in PHIPA that talks about it. It's like a pro forma document, you know, the name, the title of the research, and that kind of thing. But PHIPA does go into a lot of detail with respect to what you need to include in your plan. So you have to list the name and affiliation of all the folks involved, the research objectives, the benefits, the proposal of how it's going to be undertaken, the duration, and critical, and this is a difference and a focus, not surprisingly, given that PHIPA is health information privacy legislation, the research plan requirements with respect to information use and management of it. So the research plan has to include a detailed description of the information required and the potential sources of it, how it's going to be used, how it's going to be linked, how the linkages are going to be performed, and the description of the other information, and as well, the data that will result from the linkage and the subsequent uses of that. Key to this is, and it's something that obviously, when I was talking about the limitation principle earlier, and whether or not you really needed to use identifiable information for your project, your research plan must include an explanation of why your thesis can't be reasonably tested without the use of PHI. And again, an explanation of why the linkage is required. Again, another requirement related to what CIPP is all about, and that's why the consent can't be obtained. Why you can't go out and seek the consent of the individuals. Another information, privacy-related criteria that you've got to include in your research plan, thinking about the reasonably foreseeable harms and the benefits from the information use, what controls, what framework you've got in place to address those harms, and again, why the roles, why these people that are involved in the project do need access to the information and their qualifications for all of this. There are 14, issues in total that you need to include in your plan. Your safeguards with respect to protection of the information, how long you're going to keep it, why you need to keep it in identifiable form for that length of time. So, for example, it may be that after a certain period of time, the identifiers can be stripped. It may be that you only need the data in identifiable form to perform your linkages, and once your linkages are validated, you no longer need the raw data, so it can be destroyed. Things such as that. With respect to the safeguards, and we'll talk about this in more detail in a minute, and what we call administrative, technical, and physical safeguards for the data. When you don't need it anymore, are you going to dispose of it, or is it to be returned to the custodian? Your funding sources, whether you've applied for approval from another research ethics board, and for example, that may be one from outside of Ontario, not the one to whom this plan has got to be submitted and approved, and the response. So, for example, the custodian may well be interested in hearing that you made the same pitch to a hospital in Alberta, and one of the revs out there declined to approve it. So that's something that may be of interest to them. That's supposed to be included in your research plan description. And obviously, conflict of interest. So while some of these things that are listed in PHIPA may be those that are customarily required in a plan submitted to an Ontario Rev, it's very important to sort of have your checklist in tow to ensure that you cover off all of these items that PHIPA requires you to include. And there's just a note here for the source of these 14. And as I mentioned earlier, some of them come from the Act itself, Section 44.2, and some come from the regulation. So, one of the things that I found actually quite interesting about PHIPA and how it deals with the requirements for health information use for research purposes is how it and from one perspective, one might even say sort of intrudes, if you will, into the research ethics board space. So not only does the legislation deal with things that we would expect, you know, consent and how researchers are going to manage the information, but it actually goes farther than that. And it sets out certain criteria with respect to the constitution of the Research Ethics Board. So it's not that if you're proposing a project dealing with PHI in Ontario, you may submit your research plan for approval to any research ethics board. You must submit the plan to one that meets these 4 criteria. So again, the no affiliation with the person establishing the board, and obviously somebody knowledgeable with research ethics, and the particular methodology that's involved in the research study. But what's really interesting, if you look at this slide, is the board requirement D. One member knowledgeable in considering privacy issues. And I don't sit on a board myself, but I know that colleagues of mine, lawyer friends of mine that do, and comments that I've heard from some members who sit on boards or researchers, and they said, you know, we really need expertise on these boards that are familiar with privacy issues, and certainly recognizing that health information privacy issues are different than ethics issues. So here you have that this requirement with respect to the qualifications of one of the board members should be in this particular area. And again, not surprisingly, with respect to the REV requirements under BHIPAA, the lack of any real or perceived conflict of interest. To sort of give you a heads up with respect to what's coming, with respect to Alberta, for example, we'll see that in Alberta, as opposed to sort of setting out requirements for Research Ethics Board, what the legislation out there does is it designates a number of REVs in the province as being those to which research proposals may be submitted using personal health information in Alberta. So I suppose the general requirements, if you call them that, under PHIPPA in Ontario are more flexible in the sense that if more research ethics boards meet these criteria, then they are an authorized board here in Ontario, and there's no requirement for any legislative or changes to be made before you as a researcher can submit your plans there for research board approval. So not only does PHIPPA, as I just discussed, speak to the qualifications that a board must have, it also tells you how the board must go about its business with respect to matters that it must consider. Now, these are mandatory. That means it has to do these things. So, obviously, there are many other things that are relevant on, for example, ethics issues to an REV decision. But whatever those other things may be, included on that list must be these 4. And again, we go back to, and you'll see that these mirror the issues that you as a researcher must address and include in your plan. So whether the objectives can be reasonably accomplished without using the PHI. So again, that consideration of the limitation principle, can other information, statistical, de-identified, anonymized data be used instead? Are there safeguards? in place to protect the information. Public interest. Public interest vis-a-vis protecting the privacy of the individuals. And again, back to the impracticality of obtaining consent. And I would like to speak for a moment about this criteria, about the impracticality of maintaining consent. And a number of people have sort of asked about it, and they've certainly been wondering about it, because PHIPA doesn't provide any guidance. There's nothing in the Act. And I think that from what I've seen anyways, probably the best source of guidance on this concept of when obtaining consent would be impractical is that's found in the factors outlined by CIHR. So if you go to the website, CIHR has a very good document called Recommendations for the Interpretation and Application of Capara in Health Research. And one of the documents is a submission that CIHR presented many years ago to the Committee of the Federal Government that was looking at amending PHIPA at the time. And CIHR presented submissions on really putting some meat on the bones of this phrase, because the same phrase also appears in PHIPA. So that is the reference that I can give you with respect to how to address this issue in your research plan, and how it's likely that the research ethics boards in Ontario are going to look at this. So from a process perspective, we're now at the stage you've submitted your application to the custodian, so say to the hospital here, you've submitted the plan to a REB in Ontario, and the REB has an obligation to provide you with a written decision with reasons, and whether or not it approves the plan. And if they approve the plan, the REB may well impose conditions on that. So that should all be included in writing in the approval of the plan. And then that goes back. That approved plan is part of the package that goes from the researcher to the custodian. So that sits in the hands of the hospital at the moment. And you'll recall that the next big thing that must be undertaken to access the information is to enter into a research agreement. So here you are, you're the researcher, you've got approval for your plan, the hospital said yes, so it's time to sit down and deal with the research agreement. So what are the requirements that are going to be imposed on you as a researcher, not only from PHIPA itself, but also from, in this case, the hospital. So remember, because disclosure by the hospital is discretionary, that means that from, I guess, I'll call it perhaps a leverage perspective, they may impose any requirements that they think are reasonable and necessary in this research agreement. And it's kind of actually surprising to me that given the number of requirements that PHIPA has with respect to your research plan and the detail about the board composition and what the board has to do, the Act itself says very little about what the content of these research agreements is to be. So basically, I mean, your agreement has to include whatever restrictions, conditions that the HIC imposes, and certainly any conditions that are imposed by the Research Ethics Board approval. Most of them relate to the compliance obligations of the researcher. So the Act sets out certain obligations of researchers, and most often these are included in the agreement with the custodian. So not only as a researcher do you have obligations under the Act itself to follow these things, you have contractual obligations to your custodian because they're included in an agreement, which is actually a contract between the researcher and the custodian. And basically, custodians will do this because if anything untoward happens to the information, so for example, there is a privacy breach at the research site, there may be in this agreement reporting requirements to you. And it's important to, I think, step back a little bit here and remember that we're talking about disclosures of information for research purposes. So, in our example, when you as a researcher are provided with PHI from a hospital to conduct your research project, that is, in PHIPA terms, a disclosure. So what that means under PHIPA is the hospital's legal obligations cease, and your responsibilities kick into play. And as I mentioned, your responsibilities will be both those in PHIPA itself and your research agreement. However, what I have found in my experience is that even though from a legal perspective the hospitals may not have any responsibilities anymore for the data, there are certainly concerns with respect to, I would say, perception and that kind of thing. And if you think about it, if you're a patient, if you look at it from that perspective, I think the hospital's concerns may well be warranted, because very often, I think, patients are not aware that hospitals, again taking our examples, may disclose their identifiable information without consent for research purposes. And yes, hospitals may have notices, and I'm sure, they do have notices on their websites and brochures in the waiting room, but I'm not sure how much people absorb of that information, given that they're in a hospital for health care. So, should something happen to the information and there is a breach at the researcher site, then of course it becomes public, and it tracks back to the fact that the information originally came from hospital records. And patients may wake up to the fact for the first time that, oh, the hospital disclosed my information for this purposes. So I think that's why hospitals go, in many cases, to great lengths with respect to the requirements that they set out in their research agreement with the custodians. So if we get back to what those requirements are, as I mentioned, whatever conditions the REB may have imposed on the data, a restriction that the information be only used for the purposes in that plan as approved by the REB, not publish it in identifiable form, and not disclose it except as required by law, or to what we call prescribed entities, persons with respect to a registry, and another researcher. And I'd just like to sort of park those for the moment, because I know there were some questions about those from Deborah's webinar. Again, further list of restrictions that generally that are included in the Act. contact with individuals is not permissible unless that contact works through the custodian first and the individual consents. So, for example, if for whatever reason, as a researcher, part of your protocol requires contact with the individuals whose information you'll be using, that process should have been explained and set out in the research plan, and that you will be asking the hospital to do this and then only contacting the individuals who provide their consent. So all that part of the process is approved by the REV. And again, there's a requirement to notify the custodian immediately should one of these untoward events, as I was describing, happen and you become aware of them. So that's what the Act says. So if we deal with the perspective of the hospital, as I said, trying to manage concerns that it may have vis-a-vis the information, there's sort of a list of things that I generally include, and obviously they're based on instructions from the client, but if I'm acting for a hospital. But this is sort of generally, what I include in this. And there's quite a lot of detail. So, for example, the type of administrative safeguards. So in that bucket of safeguards, we've got things like confidentiality agreements with all of the individuals who will have access. Technical, so these are things like, for example, passwords, firewalls, storage of the data in databases. Maybe you're going to encrypt the data at rest, things like that. And physical safeguards, who could have access to the information, where are the servers stored, who's got access to any of the locations in which anything is available in paper. I generally try and deal with this particular thorny issue sometimes with respect to the length of time that the information may be retained in identifiable format and whether it's to be returned or destroyed. So, for example, if it's to be destroyed, very often hospitals may want what we call a certificate of destruction. So that's sort of an affidavit. It's a statement prepared by somebody from the research organization that has authority for the organization that said, on such and such a date, I destroyed such and such records, and this is how I did it, and this is my name and position. Or whether or not the information is to go back to the custodian. Access requirements, if somebody, for example, and it doesn't happen often, but if they want access to their PHI from a researcher, which a researcher can't give, they're to go back to the custodians. More specific timelines, if there is a breach, a description of the information, and usually really quite a very detailed description of the attributes and that kind of thing. The method of communications between the researcher and the custodian for the transmittal of the data. And obviously there are a lot of details that are project dependent. So these will be things that, given the nature of the data, the sensitivity of the data, the sophistication, if you will, of both the researcher and the hospital in our example, those will be the other drivers that dictate the provisions that will be included in these research agreements. So that sort of, I guess, summarizes that particular framework with respect to the application to the custodian, the requirements for the plan, the details of its contents, submission to the REB, what they have to look at and consider when making the decision, and taking that documentation, the approved plan, back to the custodian, and entering into a discussion with respect to the research agreement. Now, one of the questions that was posed to Deborah in her webinar on consent was this business about prescribed entities and prescribed persons. And I'd like to talk, and these are unique to Ontario, and I'd like to talk about them in the context of a point that I made earlier. And that was one of the questions that researchers often ask is, well, okay, so I've entered into this agreement, and I now have access to the data I require from a hospital, and now somebody else, I want to enter into a collaboration with another researcher, and they want access to the information, or we want to share or whatever, and what can I do? So the first comment I would make is the way PHIPA works, and given the nature of research these days, sometimes the, framework of the Act and the nature of the research project are not on the same page. In that you can see, I think, from the PHIPA approach that you pretty well have to know up front almost everything you're going to do with the information and who you're going to share it with. So, for example, things like disclosure to one of these prescribed entities or registries, disclosure to another researcher, all of those things are going to have to be addressed in your plan and not only approved by the Rev, but also you'll require the agreement of the custodian to make those further disclosures. And of course, the concern from these custodians are the farther and farther removed the data is from them, the more they may perceive there to be risks. So, for example, if we take that sort of public concern example I provided earlier, and you as a researcher here in Ontario, you've got everything signed off, and the information goes to a researcher in France, then there's something happens over there, and eventually word trickles back over here, and again there's, I would suggest, potentially a heightened patient concern, because not only did they not know that their information was going to be disclosed for research purposes, how did it ever end up in the hands of a researcher from France? So these are, in the broader context, further disclosures that PHIPA, this is just what the legislation says, researchers can do. As I said, whether or not these are approved in the protocol by the Research Ethics Board and your custodian, whose information you're going to be using, may well be another matter. So, for example, there are really three circumstances, apart from those where you're required by law to disclose them, where you as the researcher can further disclose the PHI that you received from your hospital. So, you can disclose to a prescribed entity here in Ontario. So here in Ontario there are 4. And what we mean, I should explain what the word prescribed means. And that means that these particular entities, or with respect to these persons, number 2 on this list, they're all identified and named in the regulation. So if you, for whatever reason, again, happen to be looking at the regulations under PHIPA, they specifically set out what organizations are the prescribed entities. So Cancer Care Ontario, CIHI, ICES, and the Pediatric Oncology Group of Ontario. That's POGO. Now, they are something different than what we call prescribed persons with respect to a registry. So what these guys are, entities are the organization as a whole. Prescribed persons, on the other hand, are those that basically have responsibility for a particular registry. And the disclosure from your researcher to your prescribed persons has got to be related to the registry. So, for example, the Cardiac Care Network has the Registry of Cardiac Services. They're all set out here with respect to the persons and the registry for which they are responsible. So the latest one, for example, OICR, the OTB, the Ontario Tumor Bank, just received its registry status in February of last year. And I think the thing to understand is that both with respect to the entities and the persons with respect to their registries, there are numerous requirements, both under PHIPA and those that are imposed by the Privacy Commissioner, with respect to how the entities and registries manage PHI. So if you look at what these folks do, I mean, that's basically, although generally the entities don't disclose in identifiable format, and they do a lot of data matching, they certainly have the authority to manage information in identifiable form. And in order to be prescribed, in order to have their name appear in that regulation list, they go through a very rigorous approval process. And I've worked on, you have to apply, so I've worked on some of those applications, and basically they can be 500-600 pages with respect to, you know, all their policies and procedures and all the admin safeguards, technical, physical, their agreements. So, for example, one of the things that, if you're dealing with these folks, that they may have is a template data sharing or a research agreement. And all of those documents have been sort of analyzed to the nth degree by the Privacy Commissioner's office. And there is on the website, if you're interested, a manual that the Commissioner's office has prepared with respect to how you go about applying to be a registry or a prescribed registry or an entity, and so you can see the level of detail and scrutiny, if you will, that these entities have been put through before they get named in the regulation. So all of that to say is that that's why, because of this rigorous, I'll call it, quote, accreditation process to get named in the regulation, that's why PHIPA says, as a researcher, you may disclose over the PHI you got in this case from your custodian to one of these entities. One of the questions that I also get, and this is the third permitted disclosure over by a researcher, is can you, and I mentioned this earlier, can I as a researcher further disclose this information? So remember, you've got to be sort of forward thinking, as I alluded to, in the sense of this disclosure has got to be part of the approved research plan, or it's not that the information is going to be used in research per se, but it must be necessary to verify or validate the information. So say, for example, you're looking at the integrity of the particular information that you have for your research project. And it may well be that there is another researcher that has been doing a lot of work with respect to this particular data in the database, and you require or you wish to validate your particular data set. So those are the two circumstances in which you may, as the researcher, disclose that data over further, if you will, to another researcher, as long as that's part of the approved plan by the rep, and that will be included in your research agreement. Because generally the agreements are going to say you can only use the information for your research purposes and nothing else, and you cannot disclose it further unless required by law. So if part of what you are contemplating is a disclosure to either a prescribed entity or a person for one of the registries we just spoke of, or for data validation, those matters will have to be addressed in the research agreement. And basically, I think you can understand from, I guess again, a risk management, if you will, perspective, that the hospital custodian really wants to have a sense of what's going to happen with this patient data and where it's going to end up. Another question that I don't think it was asked of Deborah, but it is a question that I get asked a lot, and there is, in my view, a lot of misinformation floating around, not only with respect to certainly disclosure of PHI for research purposes outside of Ontario, but as a matter of fact, disclosure of any personal information, be it financial, health, or whatever, outside of the country. And I think that there is this misperception spread by, from a lot of reasons, and basically sort of driven by concerns over potential U.S. government access to data through the USA Patriot Act, concerns about whether or not may we disclose the data outside of Ontario or Canada. And when I use the term disclose, I'm not only talking about, sort of data being, shipped out on encrypted CD. I'm also talking about access. So if you're managing, a database for your research purposes here in Ontario, and you're wishing to undertake a collaboration with a U.S. researcher, and the mode of data access is through some secure VPN, some secure portal, or what have you, that access alone to the data from outside the country is the same as, from a legal perspective, the same as if the data were being shipped outside of Canada. So sometimes people say, well, the data's staying here. It's just going to be that I'm providing this individual with secure remote access. And it's basically the same thing. So the question is, you're looking at doing some collaboration with a researcher outside of Ontario, so maybe in another province, or even in another country. And so the question is, may I disclose the data outside to this other researcher? So the answer in PHIPA is kind of simple and kind of circuitous, but basically it says that if the Act permits the disclosure, you may do so. And so if you've got all your ducks in a row, then, and I would also suggest that part of the plan and the approved plan that goes to the custodian also includes that particular, ability to disclose it to a researcher outside of the country. And that's important because it may well be that the custodian hospital may wish to impose additional requirements on any data or any individual researcher, for example, that is going to be having stewardship over the data outside the province of Ontario. I think we are only going to get through Ontario, so because I do want to open this up for questions, and then Khaled and I will discuss further the what we'll do with respect to the other two provinces. And it is interesting, and I'll highlight that these disclosures outside of the country for research under the Freedom of Information legislation in BC, the situation is quite different. Now, I just want to highlight that to this point in time, we've dealt with disclosure for research. So our example was that you're an external researcher to a hospital, and you're approaching the hospital because you wish access to the PHI for your research project. And that's a disclosure. But what if you actually are a researcher that works within the hospital itself? You're not somebody outside the four walls of the organization. You actually work within the hospital, and that means that you're an agent of the hospital. And there are provisions in PHIPA dealing with agents' use of information on behalf of the hospital and for limited purposes. So generally, the rules are the same. You need a research plan. It's got to be approved by a rep. No research agreement is required. But the big difference, the very big difference is this is a use. When you're managing information as an agent, it is a use by the hospital. So what that means is the hospital is still responsible for it, as opposed to a disclosure. And sometimes it's very difficult because there are real-world fact situations where there is an individual who's a researcher, they work in the hospital, but it's difficult to ascertain whether the research they're conducting is actually on behalf of the hospital or it's independent research. And it's very important because if it's on behalf of the hospital, as I just said, they're the hospital's agent, and the hospital's responsible, and no agreement's required. If they are independent, if the objective and the whole protocol is really for their independent research outside of the hospital, then it's effectively, in my view, a disclosure, in which case you need a research agreement, and the hospital is no longer responsible for it. As I mentioned, just a couple of points to wrap it up here before I open it for questions. And that is, when you're looking at a use that is within the hospital, one of the things that PHIPA directs you to is looking at whether or not what you're actually doing with the data is research. So very often it may be an activity like quality of care improvement, program services evaluation, that kind of thing. So really have a look at what's being proposed with respect to the thesis and the project being conducted. because certainly these are all activities that hospitals, again in our example, may use PHI for without the individual's consent, and as I said, don't require that the research provisions be met. Two quick points that I want to deal with because Deborah dealt with them in her previous webinar on consent. She did answer them, but I just want to review them very quickly. And that was, there were a couple of questions, I think, raised about hospital creation of data and data warehouses, databases, data warehouses, and whether or not they were permissible under HIPAA. So remember, if this is something that a hospital is doing, it is a use. And recall the consent-based scheme of HIPAA. So there's two circumstances that the legislation will allow you as a hospital to use PHI. One, if you've got the individual's consent, and two, if it's collected, used, or disclosed as authorized by a permission or requirement under HIPAA. So nowhere in HIPAA will you find any references to a use of PHI for database creation, data warehouse creation. So if you go back to first principles, there's only two ways that HIPAA authorizes the creation of a data warehouse or a database like this. So either through the consent of the individual, and you'll recall that, however briefly, we reviewed some of the requirements for consent under HIPAA, but it would require that your consent form fully inform individuals of the uses of their PHI, maybe multiple future applications, as I said, making sure that all the consent requirements are met. So that's one of the ways. The other way is, for example, if you intend to use it for one of those other purposes that sort of are, sometimes the line is a little gray between research and those other purposes, but program evaluation, and it's one of the permitted uses without consent, yes, then that's permitted. I would suggest really look at the safeguards with respect to maintaining this particular database, certainly access controls, that kind of thing. And again, I would suggest that this is one of the uses that you're going to include in your notice that you provide to patients. Second matter that, again, questions were asked of Deborah in that webinar, and I did allude to this with respect to the contents of a research plan that you present for REB approval. So this is just a repeat of what Deborah's, of the nature of her comments, and as I mentioned earlier. So first phase of your protocol, explain the process with respect to why it's necessary that you contact the individuals directly, and how that process will work with respect to going through the custodian doing the contact, getting the consent of the individuals for you as the researcher to contact it, and any safeguards of that particular protocol with respect to that first interaction between you as the researcher and that individual, and then the second phase being the particular use of the information of those individuals that consent to the contact and related to the future part of the research. So this is a summary, and I think what I should do now is open it up for questions. I apologize that this took so long and we didn't get to the other provinces, but as I mentioned, Khaled and I can speak to that, and you'll be advised. Right, Khaled?
Great. Yes. Thank you very much, Anita. There's a lot of information here, so
I know.
this is really great. So we'll just wait for the questions to come in, and if you click on the questions, Anita, it'll expand and you'll see the full text.
All right. When the text comes out, the text of the question, right?
Yes.
Yes. I don't see any yet.
Okay. There's one. I think the coloring is a bit off. Let me read it out for you.
Because I don't see it.
Okay, so I'll read it out for you. Section 446E of PHIPA prohibits the researcher from contacting a study participant without the HIC first having obtained consent for contact. Would it ever be appropriate for a HIC to appoint the researcher as the HIC's agent, thereby allowing the researcher to write to or contact the study subject directly?
No, and that's really interesting because that raises a point, even though it's not exactly the same, but again, that was discussed in Deborah's webinar on consent, and that question related to whether a researcher might also be considered to be a custodian for the purposes of provision of care. And I think to answer your question, it just illustrates the importance of clearly demarcating and clearly defining the roles of various individuals in a research project. And that is, a researcher has certain responsibilities and agents have other responsibilities. So while there is nothing specific in Section 44 that addresses the matter and or precludes the matter, I think to me it raises some risks with respect to the blurring of those roles, and the whole point of that particular provision, that is the researcher having to go through the HIC to make the initial contact, is precisely to separate and to keep that space between the researcher and the individual. I'd suggest that if this was something that you were contemplating, that for sure should be a matter that's addressed in the research plan. And again, something that should be put before the REB for approval, and consequently visibility and approval by the custodian as well.
Okay. I'll read you the questions. I think they're coming out in white on a white background, so you might not be able to read them. So the next question was, what is the permitted use or disclosure authority under PHIPA that allows for ICIS's creation of databases?
If you look at the rights, responsibilities of the prescribed entities, you will see, and I've got the act here, but where they are named in the regulation, prescribed entities, it is 45.1 of the Act is where it speaks to prescribed entities themselves. And then, again, in this particular area, as I said before, the regulations are really important. So if you go to Section 18 of the regulations, and you'll see that entities that are prescribed entities may use personal health information as if they were a custodian themselves. So it speaks to all of the things that they can do. So the uses and disclosures are in the regulations, and there is the ability of custodians to disclose to entities for those particular purposes if the entity meets the requirements in the regulation. And if you look at, again, in the Act 5, we're in 45 sub 5, where it says an entity that's not a custodian is authorized to collect any of the information that the custodian may disclose. So the way PHIPA works, as you may be aware, when PHI is proposed to go from one organization to another, the PHIPA, rights have to be mirrored. So that means, in this example, the custodian has to have the authority to disclose, and ISIS has to have the authority to collect. So what 45 sub 5 says is that if a custodian has the authority to disclose under 45.1, in parallel, the mirror section is 45.5, which allows ISIS to, as a corollary, collect the information. I hope that answers the question.
Okay, thank you. The next question is, where in the Act is the composition of the REB prescribed? I'm having difficulty finding this.
Okay, if you, again, these very, very important, it is Section 15 of the General Regulation. So it's Regulation 329.04 under PHIPA, and it's Section 15. It's titled Research Ethics Boards, and it says the following are prescribed, and as I said, that means set out in the regulation, as requirements that must be met by a research ethics board.
Okay. And the next question is, how are requests for disclosures to be handled from the lens related to PHI?
From the lens? You mean if the LIN itself gets a request?
I'm assuming so.
I'm not sure.
LIN is requesting data, PHI, from a health information custodian.
The LIN, but as a researcher? Because
don't
a
know.
LIN. Okay. Well, I'll just briefly make a couple comments because I'm not quite sure that I fully understand the question. But again, back to the sort of big picture scheme of PHIPA, all the players in the health system sort of are identified by certain roles, and associated with those roles are rights and responsibilities. So a LIN itself is not not identified as any one of those players, like the local health integration, the network isn't identified as one of those players. So I'm not sure if you're talking about like the LIN or one of the organizations within the LIN. So perhaps if you could expand your question a little more, I might be able to respond.
Okay. Next question. Does Section 45 of PHIPA authorize prescribed entities to collect human tissue for genetic purposes?
Yes. Well, this is kind of interesting. 45. This again will take you back to some definitions under PHIPA. Now, if you look at PHIPA is really focused on personal health information, as I said. And if you look at how that term is defined in Section 4 of PHIPA, the only reference to tissue, bodily parts, or something like that speaks to, in Clause 1G, about donations. of body parts or substances as falling within the definition. So it does not, and what I don't know is I'm thinking that with respect to OTB and its approval as a registry under OICR, the Ontario Institute for Cancer Research, it may be that that matter, tissue samples, were considered to be PHI, because if you look at the definition, I don't think it's really exhaustive. So to answer your question, I am not 100% sure of how that was treated under ODB. I can just tell you that by looking at the definition of PHI on its face in the legislation, it does, it may not appear, let's put it that way, to capture that type of information.
Okay. Another question about, I'm just trying to view these here. Is an approval from an REB required for collection of PHI data in research databases for future use?
Okay. Well, if it is a research project, regardless of whether it's a database, a current use, or a future use, if the purposes of the collection of the PHI at first instance are for research purposes, then yes, REB approval is required.
Okay. Then this is a question about pre-screen activities. So, like chart review, I'm assuming here the objective is to determine how many patients would meet the criteria for a study. So pre-screen activities in the research proposal, with a copy of the proposal reviewed and approved by the REB and the custodian of the records, so the hospital, let's say. Would this be allowed under Manitoba legislation?
Well, that's a good question, and I'm afraid that I cannot provide you with the answer.
Okay. Well, the next part of the question is, would you need personal participant consent for pre-screening activities such as a chart review, let's say in Ontario, since this was the scope of our presentation today?
Well, okay. Remember, and this is something that I didn't discuss, but the research framework in PHIPA, what the discussion that I went through today, all relates to collecting, using, disclosing PHI without consent for research purposes. Now, certainly, like any of the other provisions of PHIPA that say you may deal with information without consent, you certainly may undertake that activity by obtaining the consent of the individual. But remember, I mean, and again, Deborah mentioned this on the last webinar, you run the risk if, for example, you want to review charts during a certain period of time, patients that fit certain demographics or whatever, to see if you can identify those patients whose information will be necessary for the protocol, then if you're structuring all of this on a consent basis, you run the risk that individuals will not consent.
Right.
So, and that may very well limit the sort of, I guess, demographics, if you will, of the charts that you can review to identify individuals whose information may be relevant for your purposes. So and the other thing too with operating on a consent basis in research is that because it is consent, individuals have a right under PHIPA to withdraw their consent. So you'll have to deal with those issues as well.
But if it's done in preparation for research, consent would be required. There's no exemption or escape route, so to speak.
Exactly. And I was just discussing, if you decided to approach that chart review on a consent basis, as opposed to including it, for example, as a phase 1 as part of your research plan submitted to the REB for approval.
Okay. So I think we'll take so many questions coming in, Anita. Okay, we'll take this one.
Everybody, there's fortitude out there.
So I represent a biobank operating within the government health services housed within hospitals. We collect PHI for our database and disclose it in a de-identified format to researchers who meet the requirements described: RB approval by our own biobank committee, signing of an agreement to not attempt relinkage, communication, publications, and not sharing biased specimens or health data to others not listed in the application, and so on. In your opinion, are we agents of the HIC or agents and a HIC? So this is a biobank operating within the government health services housed within a hospital.
It depends on where the information is coming from. So you're a biobank that was created by I would say it depends on a number of things. I think that, before I would answer the question, I would ask some questions, and which is what I often do. But it would be, I think I would look at the relationship between you as the biobank and government services. So, for example, how are you established? What's your authority? What's your boundaries and sort of responsibilities with respect to doing research? Then I'd also look at, why are you housed in the hospital? Are you just there because there's space there, or because much of your samples are coming from that particular hospital? Where does your mandate to do the research come from? Are you really acting for the ministry, for the government in doing this research? And as I say, you may be housed in the hospital physically for convenience purposes, or in effect, are you really doing research for the hospital? So I think there are a number of questions that you've got to look at before you could sort of come down on one side or the other with respect to what your role was under PHIPA in your conducting of your research.
Okay, great. I think, Anita, we'll close it here. So it's been an hour and 40 minutes. We've taken up a lot of your time, but I've put up Anita's contact information on the screen. So if anybody has any additional questions, you can contact her directly, send her an email, and we will. I think I'll talk to Anita after this and see if we can have part 2 of this to cover Alberta MBC, because I think a lot of our attendees were also from these 2 provinces, and we'll let you know. Thank you very much, Anita. I really appreciate the effort and time you put into this. As you can see, there were a lot of questions, a lot of interest, and clearly a lot of uncertainty still around the issue of research and sharing information for research purposes. So for the folks on the line, we will post the recording and the slides soon, and we will inform you about a potential part 2 to continue the presentation. And just to remind you that we do not automatically put you on our mailing lists for webinars. You have to opt in. You'll receive an email letting you know where, in the email letting you know about the slides. You'll receive a link if you want to be added to our mailing list to be notified of future events related to privacy and ethics and data sharing. Then please register, and we'll keep you up to date. Anita, did you have anything else you wanted to say in closing?
I just wanted to thank everybody very, very much for your time, particularly over lunch hour. And for those of you who are out west, I apologize for not getting to Alberta and BC. But as Khaled said, you'll be advised if you get yourself on the lab's mailing list, whether and when rather we do part 2. And perhaps, and Khaled and I can discuss this, whether part 2 might also include addressing some of the questions that I was unable to answer today.
Okay, excellent. Thank you very much.